All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazers, Mr. Neufeld, Mr. Snyder Chapman, people represented by Ms. Clark, Mr. Darden, and Mr. Gordon. The jury is not present. Counsel, yesterday I stayed in the courthouse till after 6, and Mrs. Robertson was here well after 7. And we did not receive the materials, and apparently you've given the materials to Mrs. Robertson this morning, correct?
Before I left, you were calling, and I came back and indicated that you had it first thing on. I didn't come back and tell you that before you left. What's my understanding? I told you that.
My recollection is Mrs. Robertson and I were waiting, but
My understanding was I came back.
the point, counsel, the point being is that that's another evening that I didn't have to work on these materials.
I understand. Let me do this. This,
No, counsel, all I'm pointing out to you
Yes.
is this. What you have presented to me with regards to these tapes and transcripts is a very prodigious task.
you just don't know how prodigious, Your Honor.
Oh.
And that's why I wanted.
I know.
No, you do not know. You do not know. Let me may I just say something for the
No,
record?
counsel, the only point I'm making is that given the volume of the materials that I have before me, you should not anticipate a ruling on this issue this week.
We
That's
don't,
the
Your
point
Honor.
I'm making.
Let me just say this. We try to be reasonable. Judge,
Oh, I
let me tell you,
understand that.
I had to stop my entire office. I've had 3 secretaries for over a week working around the clock. In addition to that, Judge, I mean, I have a flourishing law practice. I had to stop them to do this. In addition to that, we're also cleaning up tapes. We have now, so that because of Your Honor's ruling, which we take some exception to yesterday, your memo, that we have now keyed in our tapes with the proffer, along with her tapes, which weren't verbatim. In addition to that, there were some tapes she had not transcribed. There are now 10 additional N-word references. There are 40 instead of 30.
Mr. Cochran, I'm going to cut you off right there.
Okay.
The only point I'm making is that I have a lot on my plate right now.
I understand that,
You're
Your
not going to get a ruling on this until sometime next week. That's my point.
Okay, and I have no problem with that, Your Honor, and I
All right, so
understand that.
plan your witnesses accordingly.
It's a lot of work, and I understand that. We are, and I understand, well, I don't know if we have any dark days or all this week, but at any rate, we will be prepared to deal with that.
All right.
We are prepared today. And may I just indicate to the court what we expect and what we need to do today at this point? I have present today Dr. Christian Reichart, and I would like to do a 402 motion regarding his testimony. We have Detective Ken Burris. We flew in from Chicago. I want to do a 402 regarding him. Mr. Howard Weitzman will be here at 10:30. I want to make sure there's a 402 regarding Mr. Weitzman. Sean Chapman is here today to argue the Menzione matter. We want to tell the court what we have before I bring her out here for Thursday. So we'll save some time. We're flying witnesses in and out. We're very aware of that. And of course, Dr. Henry Lee is in the wings.
Before you get further down the path, once you approach, let me just chat with you off the record.
All right.
All right, thank you, counsel.
There's one other matter. We would like to recall Mr. Larry Regal to the stand, Your Honor, for the following purposes, and I can make an offer of proof the court would.
I was wondering why Mr. Regal is still here.
Right, because we want to, Mr. Blazer would like to recall him to the stand, and I'd like to make an offer of proof the court would care to hear it.
Mr. Goldberg is not present.
Okay, I'm sorry.
So
Is he available?
We will call for him.
All right, let's have Mr. Regal down. Why don't we proceed to the, you wanted to have a 402. I take it this is in the form actually of an in limine motion to restrict certain cross-examination of Dr. Reichert? Is that what?
Yes, Your Honor, it certainly is.
All right, why don't we do that since we have all the,
All right.
my recollection is Mr. Darden was the attorney on the prosecution side who was going to be conducting the cross-examination of Dr. Reichert. Is that correct?
That's true.
Okay,
So we're going to have a motion in limine on cross-examination?
that's
future
my understanding.
cross-examination?
That was my understanding what the request was.
That would seem to be a rather unusual procedure.
No, my recollection is that both sides have availed themselves of that several times in this trial. Mr. Cochran, what issue do you wish the court to determine before we call Dr. Reichert?
Reichert to leave before we do the courtroom?
What's the issue?
The issue, Your Honor, is as follows. I anticipate calling Dr. Christian Reichert, who's present with his lawyer, Mr. Dominic Rubalcaba.
I see Mr. Rubalcaba in the back row.
Yes, he's injured today, but he's with us at any rate. Your Honor, I anticipate it'll be very, very simple and direct examination. I expect that Dr. Reichert will testify that he first met.
All right, I just want to know what the issue is.
The issue has to do with the scope of the direct and whether or not the prosecution is going to be able to bring up issues which aren't covered on direct. And I'll be very right to the point.
Mr. Rubalcaba, can we have your client step outside, please? And I'll allow you to remain.
Thank you, Your Honor. In the course, and let me just, as an offer of proof, lay out what I expect the direct to be. It'll be very brief, and then you'll get an idea of where we'd like to limit any other examination will be beyond the scope. Dr. Reichert, I believe, will testify that he met and became acquainted with Mr. Simpson sometime around the middle of 1993. Thereafter, they were friends. They knew each other over a period of time. In fact, in the earlier part of 1994, Dr. Reichert was paid, I think, $5,000 for his work on the video in which he did some background and worked with Mr. Simpson about the perils of traveling, jet lag, drinking water, walking around the plane, things of that nature. He did a major script of 50 pages, reduced down to 5.
Was that the portion in the exercise video?
Yes, that was the resulting portion of that he had participated and helped out with that.
So
with
they
Mr.
had,
Simpson.
they had a business relationship?
Yes, they had a business relationship, and he was paid for that over a period of time. But they continued to be friends. He was aware of Mr. Simpson's relationships. They talked that on June 12th, and specifically getting to the point we want to bring out, on the date of June 12th, 1994, Dr. Reichert received a call from Mr. Simpson at about 9:00 p.m. that evening. Mr. Simpson was jovial, was his usual self with regard to his demeanor. They had a conversation at that time. During the conversation, Mr. Simpson talked about what he was doing with his life, that he was on his way to Chicago, and that they made basically a date. They wanted to get together on Wednesday of that week, which would have been Wednesday, June 15th, I believe. They made a dinner date or plans to get together when Mr. Simpson returned back from Chicago. That he will testify that Mr. Simpson didn't sound any differently than he has on other occasions. In fact, he sounded really upbeat and happy, and they had a very good conversation. And that's pretty much it. It'll be with regard to the conversation, the demeanor, the brief business relationship they had, that he was aware also of Mr. Simpson's personal life, who he was seeing at various times, and that's it. Now, I don't expect to go into any of these other incidents that occurred before that time. I don't expect to elicit anything regarding Faye Resnick and her drug treatment program or anything of that nature. I want to limit it just to these things, and I think the prosecution would be accordingly limited, and that's why I'm doing this now, so we'll have an understanding and move ahead.
Mr. Darden, any
It
response?
seems to me that he has something specific in mind, that is something specific he doesn't want me to go into, and perhaps we should ask Mr. Cochran what exactly that is. And if we're talking about bias and prior business relationships and his attitude toward these proceedings and things like that, which are traditionally areas that are fair game and cross-examination, and of course I assume that I will be permitted to pursue those issues. I don't intend to ask about Faye Resnick and her
You do not.
and her drug usage. I mean, geez, we fought that issue, so why would I do that now?
I was kind of wondering that myself, but, things seem to change here from time to
Okay,
time.
sure. And nor will I ask him, this witness, about whether or not he's ever used drugs. Not that I'm saying that he has, but so what do we have in the 402?
This is someone on the side who asked for 402 on every hearing.
Well,
I'm just trying
counsel.
to narrow the issues, Your Honor.
Let me just explain something to you, just so we all know what the court's thought process is at this point. I would like for this jury to begin deliberations on this case sometime shortly after Labor Day, is my hope and expectation, which means that scope of examinations are going to get tightened and have been tightened. And if you recollect from the court's rulings yesterday regarding Mr. Regal, if there were scope problems, I enforced those restrictions. Now, attitudes and opinions, other issues regarding testifying, clearly that's under the evidence code and under Calgic 220. That's an area that Mr. Darden's entitled to go into. But it has to be impeachment that's relevant to the issue. And we know since we've had these discussions informally before, we pretty much know what Dr. Reichart is going to say.
Sorry, I didn't hear the last.
We pretty much know what Dr. Reichart is likely to say at this point.
Yes, I do.
Okay.
And no one can accuse me of a lengthy cross-examination of any witness. I think I'm the only one in this.
All right,
case.
well, then the more we talk about it, the longer this morning session's going to take.
Yeah.
All right, let's proceed.
All right, may I ask this one other thing, Your Honor? If there's an area of alleged impeachment regarding Dr. Reichart, I would ask that the court, that either side, that certainly the prosecution approach the bench so we can argue it before it's asked, some question is asked improperly before the jury. That's been our general rule. Would that be the rule here also, Your Honor?
I'm sorry, I'm not going to ask any improper questions, Your Honor.
Well,
But I will hand over any documentation I have just before I go into that area.
All right, thank you.
now, Your Honor,
And Mr. Rubalcaba, do you want to come forward, be available to consult with your client?
Your Honor,
Have you been riding motorcycles?
perhaps a comfortable seat might be in order. He's here under in great stress and pain. Your Honor, may I then move on, given that, may I move on to the issue?
You want to
regarding
sit closer to you want to sit closer to the witness, or his seat? That's the bailiff's seat, so we'll need you over here.
Thank you.
All right, thank you, Mr. Rubalcaba.
May I address also the issue regarding Howard Weitzman, Your Honor, so we can move right along?
Yes, sir.
All right, with regard to Mr. Weitzman, we expect, as I said, he'll be here around 10:30. This hearing would be, and we've talked about this also, so I think everybody is aware of this. We do not expect to get into any attorney-client communications. I do not expect, the court will recall that Mr. Weitzman had represented Mr. Simpson back on the 1989 incident. We're not getting into that. I'm not getting into any communications between Mr. Simpson and Mr. Weitzman from 89 to the present. That I don't want to get in any statements made by Mr. Weitzman publicly or privately or anybody in his family. These proceedings, Your Honor, the lawyers, that's all irrelevant. I expect only to go into his background briefly. He is a lawyer, that he was called on June 12th. The jury's already seen the video that go briefly into his background, June 13th, rather. He has a distinguished background, obviously, and I'll go through it briefly.
Well, let me, Mr. Cochran, let me help you out here. What you're saying is you want me to enforce the scope objection regarding any cross-examination, and you want the court to be wary of any attorney-client issues. Is that
That's
what
exactly
you're,
correct. And I
all
want to
right.
go into, with the issue I want to get to, right to what happened at the time of the statement and what he was told, and that's it.
And that's to impeach, this is
By
to
the
impeach the
Detective
testimony
Van
of
Adder.
Detective Van Adder.
That's exactly correct. And I've told the court this before, and I want to make sure that everybody understands that.
All right.
I want to deal with that.
I'm sorry, who's going to be handling Mr. Weissman? Ms. Clark?
Well, I'd really like to know what counsel's talking about. What testimony is it that he's supposed to be impeaching? We have not entered a statement.
No, it has to do, I think, with the nature of the timing, location, and circumstances of Detective Van Adder talking to Mr. Weitzman, who was allowed to be present, who wasn't. There's apparently a factual dispute.
Your Honor, what difference does the factual dispute make if we have not introduced any evidence of the statement? We have not introduced one thing about the manner in which the statement was taken, the content of the statement, Mr. Simpson's demeanor, or any interaction with Mr. Weitzman. What is the relevance?
Very relevant. Van Adder, and I'll show you the testimony of what Detective Van Adder said about who could be present during the statement. It's directly impeaching,
What?
and that's all.
All right.
I'd like to see the relevant transcript portions, Your
We'll be
Honor.
glad to show
I
it
do
to
not
you.
recall Detective Van Adder ever testifying
We have
to.
it. We'll be glad to show it to him.
All right, well, why don't you show it to her, and then what we will do is we'll proceed with recalling, oh, I'm sorry, Mr. Goldberg is back. We have Mr. Regal still present.
Right.
So let's have the offer of proof from Mr. Blazier as to the recalling of Mr. Regal. Let's get Regal out of the way, and then Dr. Reichart. And then
Your
you
Honor, so the
guys,
court is clear on this Weitzman issue. We have Miranda waivers on tape from the defendant.
the issue goes to the attempt to impeach Detective Van Adder. Why don't you look at the transcript portion, and we'll take a look at it. Mr. Blazier, what's your offer
Good
regarding
morning, Your Honor.
recalling Mr. Regal?
Your Honor, after Mr. Regal was done testifying yesterday, he came off the witness stand. He had seen Detective Van Adder sitting in the back of the courtroom during his testimony, or in the back bench there. He put his hand out to shake his hand, and Detective Van Adder backed away and stated, "I'm not going to shake your hand. You are a traitor," or a word to that effect, or that substance. "You should be ashamed of yourself. I'm a cop. You're a cop. You're pathetic. I've been a cop for 27 years, and I've never seen a cop come in and testify the way you did." Now, we want to put Mr. Regal on to state that. It's directly relevant to the bias of Detective Van Adder, of his motives. It shows it's state-of-mind evidence on Detective Van Adder as to his feeling that cops should not testify against cops. That's the central aspect of our defense, is the code of silence of the police department, and it's relevant to Detective Van Adder's credibility, and we wish to call Mr. Regal to demonstrate that. It's relevant to bias under Evidence Code Section 780. It's evidence of a habit and custom of the police department or Detective Van Adder of not wanting to say anything negative about another police officer.
Mr. Goldberg?
I'll handle this, Your Honor. This is ridiculous. I mean, we have really reached the farthest reaches I've ever seen. I'm actually speechless. I can't believe what I'm hearing. Detective Van Adder is entitled to his opinion. He's a human being and a citizen of this country, and he's entitled to his opinion. And if he wants to tell Mr. Regal, after he's completed his testimony, what he thinks of him, he's entitled to do so. And if Mr. Regal feels the need to go and cry to his lawyers about it, he can do that too. But none of it has anything that should be involving this court's time and attention and energy, which are already sorely taxed by a very difficult and lengthy case. This is absurd. These people want to put on everything they can think of, whether it's relevant or not, to slime the police department. I understand the motive. We've seen it in every case. This one is no different, just a slight bit more. It's more extreme. But to say that it's relevant, that Detective Van Adder voices an opinion of someone he feels to be unethical, he's entitled to do that, as am I. He did not try to dissuade the witness. The witness completed his testimony, went up to Detective Van Adder, and wanted to do the same thing that all these witnesses do. Excuse me for basically lying on the witness stand or saying things that I really don't believe in.
Wait, Ms. Clark. That's not called for.
I apologize, Your Honor.
That's not going to be tolerated. Why don't we have, wait,
Regal,
Ms.
of course.
Clark, let's
Yes.
have an intelligent discussion here. Mr. Blazier raises the issue of bias and habit and custom. He raises two legal issues that you have not addressed. If you don't want to address those, then I'll assume those grounds to be well taken.
As to habit and custom, Your Honor, Mr. Regal went over to Detective Van Adder. He approached Detective Van Adder, not reverse. He was the one that sought out interaction with Detective Van Adder. He was the one who went and made the overture, wanted to say let bygones be bygones or whatever he wanted to say. Detective Van Adder gave him his opinion. There is no habit and custom shown here. There's no code of silence shown here. Detective Van Adder, if called to testify, would say that many of the statements made were misrepresented by Mr. Regal. And I can understand where there would be misunderstandings between two people when tempers flare. However, habit is more than one occasion, Your Honor. There's no habit shown here. There was one encounter that Mr. Regal didn't like that the attorneys wished to capitalize on. Habit has not been shown. As for bias, Detective Van Adder has an opinion of the witness's testimony. That doesn't reflect bias in terms of his relevance as a witness in this case. He has an interaction with someone who has completed his testimony. And the fact that a witness in a case has an opinion as to guilt or innocence, or has an opinion of a witness's credibility, does not make him biased as a witness in terms of giving his testimony. He's entitled to it. He's not on the jury, Your Honor. He does not have to withhold his opinion. And I don't understand how this could possibly be relevant to his bias, quote unquote, as a witness, when he testified, what, 6 months ago at this point? Detective Van Adder is entitled to have an opinion about someone else, to voice that opinion when the person approaches him to have an interaction without that being called habit and custom, code of silence, or bias as a witness. And if we have to, then we'll convene the mini trial of Detective Van Adder and Larry Regal. Then we have to recall Detective Van Adder to set the record straight, say his true state of mind, which would make relevant his opinion of Mr. Regal's credibility and the nature of his testimony. That's what this would open up. Obviously, none of it's relevant. One witness's opinion of another's demeanor on the witness stand is their opinion. And when that witness approaches another and asks for the interaction, there's no reason why he can't voice that opinion. But to do so once certainly is not a habit or custom.
Detective Van Adder, when he testified, made many statements about the actions of other police officers, Detective Furman and others, in terms of what they did or what they did not do, whether things were done properly or improperly. His state of mind, as evidenced by his statement yesterday, is relevant, and that is that you don't say anything negative about another police officer, and that is directly relevant to his credibility, and we offer it for that purpose.
All right.
And the statements made were twisted to be offered for that purpose. As I understand it from Detective Van Adder, that is not what he meant or what he said. He simply offered his personal opinion of the witness's credibility and demeanor on the witness stand. Not, you don't criticize another police officer. It was rather, I'll tell the court what it was. You haven't investigated a crime scene in 20 years. How could you possibly know what you're talking about? I dare say there might be one or two others in this country that might share that opinion, but it certainly has nothing to do with a code of silence or habit and custom, Your Honor.
Now then, we always
I'm
have
concerned that both attorneys from both sides have referred to what other people around this country may think. That causes me to believe that the lawyers are pandering to the cameras, and that causes me to believe that probably I ought to pull the plug on the cameras. I'm contemplating doing that. So I'm tired of this kind of argument. All right. Any other comment?
No, Your Honor.
All right, I'm going to sustain the objection to the recall of the witness as to that issue for this reason. The probative value, since we have a dispute as to what that statement actually was, I find the probative value to be minimal. It will also prolong this trial by requiring the prosecution to recall Detective Van Adder to explain why it is that he holds this opinion, plus or pro or con, with regards to Mr. Regal, which will get into all sorts of inadmissible hearsay. And I think that given this isn't even remotely collateral, and I don't see any point in prolonging this trial. I think it's an undue expenditure of the court's time to engage in this kind of thing, so I'm not going to allow it.
May I inquire of the court, Your
All right,
Honor?
let's have Dr. Reichert.
Because we haven't said, there's also another witness here from Chicago, Mr. Barris, Your Honor. And again, I want to just briefly take up with the court the issue and as an offer of proof. Mr. Barris is the officer we flew in last night from Chicago, who had responded to the hotel room at the Oak Park Hilton Hotel.
I recollect who he is.
About 11 o'clock, and he, along with some technicians from the Chicago Police Department, ultimately took possession of the knife, of a glass, the sharp glass,
Towel.
the shards of glass, the towel, et cetera.
I know
and then
who
they
he
were
is.
then transported. Then Looper, of course, took it out. I expect to ask him some questions, limiting it to just those things, not any other part of his investigation. And again, I'm just pointing it out to the court so we can have this same limit you talked about with regard to cross-examination, that sort of thing.
See what my cross-examination looks like. I intend to ask him about his observations of in the room. I don't know what is it that he's asking me to limit,
I think he doesn't want to go into the forest searches or any of that kind of stuff.
or means of escape from the hotel and all of that
I
good stuff.
suspect.
I don't know that. I would think that would be relevant.
I think not, Your Honor. That's the reason I'm making this motion at this point now.
Well-
Try to limit it so we can move through. Your court has just said, want to get this case to the jury by Labor Day. We concur and love to try to do that. We're trying to call these witnesses. I'm telling you up front what we're calling them for, and I'm trying to get some understanding of where we are. We can move ahead.
Problem being is we have a witness from, in this instance, a witness from Chicago that is not easily recalled. That's
Understand
our
that.
problem.
But what does that have to do with anything, Your Honor? If we are calling him, it's our case. You said we can try the case a certain way. You've said that 100 times. We're the ones who brought him out here. Mr. Simpson's the one who's
Well,
paying.
let's see where it goes. Let's see how you lead him into this.
I'm already told you how I'm going to lead him into this, Your Honor, and I'm just trying to give the court a
But
heads
if
up.
he's
on
there
this.
conducting an investigation in that room or at that hotel, it depends on what he was doing.
I indicated to the court he was there conducting an investigation into that room, and that's exactly the operative words, in that room. That's
All
the
right,
point I'm trying to
well,
get to, Your Honor.
that's what it sounds like to me.
Okay, and I need 5 minutes because he just got here this morning. I need 5 minutes. He would probably be the first one, and then Reichart, and then Weitzman, the way things are going. The last thing, Your Honor, we do have the Menzione motion to the court. Care to hear that at some point before we get to...
Well, I'd like to
Dr.
get
Lee.
to the jury and get some testimony under our belts.
That's fine. We'd like to get that under our belts also, Your Honor. I'd like just a few minutes to finish with those two witnesses. I'm ready to roll then.
Who's going to do Dr. Reichart?
I am.
Are you ready with Dr. Reichart?
I need...
I'd like to get Mr. Rubalcava on his way.
And I would like to do that also, Your Honor. I need, give the court, give me 5 minutes for Reichart and Barris to finish talking with him.
Before you leave the bench.
You're,
As it appears you're about to.
you're assuming I'm going to give him 10 minutes?
I don't think he needs the time, but Judge, before I was cut off, I wanted to inquire of you, now that the defense case is going to be prolonged a number of days, what day should we be prepared to have rebuttal witnesses appear?
Well, I mean, this tape motion, I mean, we're talking about 18 incidents and 30 other incidents,
No,
so,
that's 40. It's 40 and at least 18 or more.
you know,
I'll indicate to you.
so we're talking about individually, 50 or 60 individual rulings and arguments that I'm going to have to hear. This is going to be much like the domestic violence issue where we have to deal with dozens of issues, each of which is entitled to a separate ruling by the court, each of which the court has to weigh under 352. So you're talking about a significant argument and then time for me to think about it and sort it out. So from the experience in the domestic violence issue, since you handled that argument, I assume it's going to be similar. So my guess is it will probably, that endeavor alone will take a couple days. Argument and then the court's analysis and ruling on the issue.
There's one difference out here. In this instance, we have tape recordings in addition that you've previously ruled in January.
Well, I seem
So
to
we've
recollect
limited-
during domestic violence, we had tape recordings.
But we've limited, well, you had one tape, Your Honor. This instance, you have a ongoing tape recording of this person's voice, but you've also ruled in January. The proffer goes into the areas, only the areas, I mean, there's, 16 hours of tapes. So we've limited down to just the areas you've talked about that are relevant. So I just want to point that out. But whatever date you say, it's fine. What date?
No, Mr. Darden wants to know when he should start subpoenaing in his witnesses. My guess would be September 4 or 5th, actually, since that's after Labor Day. I don't see us resolving these issues and concluding the defense testimony before then, because we still have Dr. Lee.
Reproach.
All right, why don't you take your 15 minutes, 10 o'clock.
10 o'clock, that's fine.
10 o'clock, all right. All right, back on the record in the Simpson matter, all parties are again present, jury is not present. All right, Deputy Magnaro, let's have the jurors, please.
With regard to our earlier, with regard to our discussion sidebar, the court, I think, indicate that perhaps the people should subpoena their witnesses around the 30th of August for rebuttal.
Yes,
Thank you.
thank you.
Your Honor, I think maybe the court is aware of the timing of this, that we filed our points and authorities in response to the initial proffer made by the defense. At the same time as we filed that, the defense filed points and authorities. What I wanted to ask the court is whether it would prefer that we file a response to those points and authorities, because obviously our papers couldn't be responsive, they were filed simultaneously, to the defense points and authorities in writing or orally argue it.
Well, that's up to you, but if you're going to do it, you need to file it by Friday, close of business noon.
Okay. Okay. We will do our best to.
Because obviously this is going to consume my entire weekend.
Right. Right. Just to offer some ray of hope, because I personally am very upset about the extension of time of this case. I would, and I apologize to the court for losing my temper earlier this morning. The extended time and
Well,
delays.
isn't it amazing how much smoother things go when we address the specific issues?
I agree, Your Honor.
All right.
I'm certainly not arguing with the court. I'm apologizing to the court because,
Just an observation, not a criticism.
yes, and I'm going to try and rein in my personal aggravation at, things we can't help. But by,
We're all tired. All right, the record should reflect that we've been rejoined by all the members of our jury panel again. Good morning, ladies and gentlemen. All right, the defense may call their next witness, Mr. Cochran.
Thank you very kindly, Your Honor. We'll call Dr. Kristen Reichardt.
All right. Mr. Reichardt, you come over here and stand by the court reporter, please, and face Mrs. Robertson, the clerk.
Raise your right hand, please. Do you solemnly swear that the testimony you give in testimony before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please will proceed on the witness stand and state before your first and last names for the record.
All right, would you sit back and pull the microphone towards you, please? All right, thank you, Doctor. Mr. Cochran.
Morning, ladies and gentlemen. Morning, Dr. Reichardt.
Good morning.
Dr. Reichardt, what is your occupation, sir?
I'm a doctor of chiropractic.
And for how long have you been a doctor of chiropractic?
I graduated in 1983.
And where did you graduate from, sir?
National College of Chiropractic in Chicago.
And did you start to practice thereafter?
I practiced for 1 year in Chicago and then moved to California.
And are you presently in the active practice of chiropractic practice here in Southern California?
Yes, I am.
And where are your offices, sir?
I have an office in Malibu and another office in Santa Monica.
Now, I would like, sir, to direct your attention to the gentleman over to my left here, Mr. Orenthal James Simpson. Are you acquainted with him?
Yes, I sure am.
Will you tell the ladies and gentlemen of the jury when it was that you first met Mr. Simpson?
I met Mr. Simpson in the early summer of 1993.
All right, and thereafter, did the two of you become friends?
Yep,
And,
sure did.
Would you see him socially?
Absolutely.
All right. Did there come a time in 1994 that you had occasion to enter into some kind of a business relationship vis-a-vis a video that Mr. Simpson was to be in? Did that happen?
Yes, it did.
And when was that approximately?
Well, actually, in the later part of 93, we were talking about healthcare and exercises and so on and so forth, and an opportunity came up to do a video for Playboy magazine that was about jet lag and healthcare for the frequent flyer and frequent traveler.
And this was something that you and Mr. Simpson discussed, putting on a video to aid travelers with regard to jet lag and that sort of thing?
Yeah.
All right. What role did you play in helping to get this video ready and helping Mr. Simpson in that regard?
I wrote about a 60-page outline for him, talking about nutrition and exercise and things that a traveler could do while they're on the plane, what to eat, what not to eat, things like that. We
So-
actually made also up a little exercise piece of equipment, a little rubber band that the traveler could take with him in his suitcase to be able to continue a workout program in his hotel room.
So you spent a number of hours on this project,
I'd say about 60, 65 hours.
and were you paid for your efforts?
I was paid in the moment when there was an agreement made that the Playboy will go ahead with the video, and then I was paid.
And how much were you paid?
I was paid $5,000.
So you did a number of hours for $5,000, is that correct?
Definitely more hours than I would have made the $5,000 in my practice.
All right. Now, with regard to that video, have you ever seen that video?
No, I haven't.
You never saw it afterwards?
Nope.
All right. But the part that you participated in had to do with how one would overcome jet lag and drink water and get up and walk around and things like that?
Right.
All right. Now, your relationship and friendship with Mr. Simpson, did it continue then in 1994?
Yes, it did.
And specifically, I'd like to ask you, on the date of Sunday, June 12th, 1994, did you receive a phone call from Mr. OJ Simpson in the evening hours of that day?
Yes, I did.
And can you tell us approximately what time that call was?
That was about 9 o'clock in the evening.
9 o'clock p.m.?
Yeah.
All right, and tell us where you were when you received this call.
On the couch at home.
All right, were you alone at that point?
Yes, I was.
All right, and tell us what happened during that phone call.
OJ called to just check up on me and see how I was feeling because he knows.
Sustained.
Let me ask you some questions. Mr. Simpson called, and you, of course, recognized his voice, did you not?
Absolutely.
And with regard to the tone of his voice, I want you to describe how Mr. Simpson's voice appeared during this conversation at 9 o'clock p.m. on Sunday evening, June 12th, 1994.
Oh. You can answer the question.
You may answer it.
He seemed a little bit more relaxed than in the recent months. He seemed very jovial.
All right. And you recall this specifically?
Yeah.
Did he seem downcast or sad at all during this conversation?
Not at all.
Well, I'm asking the question. Well, I can ask it another way.
Yes, you can.
Describe for the jury how O.J. Simpson seemed to you.
Hold on.
Attorney Young.
Yes, that answer is stricken. Since I sustained the objection as being leading, ask another
Thank you.
question.
Describe for this jury how Mr. O.J. Simpson seemed, how his voice seemed to you during this conversation at 9 o'clock on June 12th.
Yeah, like I said, he seemed more jovial. He seemed relaxed. He was packing his bag to go to Chicago. And we were talking about the fact that he's going to come
Okay,
back.
wait. Doctor, please listen very carefully to the question. It was just describe his tone of voice, not what he said.
Okay.
All right, jury is to disregard the testimony regarding what was said. Mr. Cochran.
All right. So anything else you can describe regarding his voice?
Just more relaxed than usual.
Okay. And how long did this conversation last?
I'd say about 15 minutes.
All right. So you talked about from about 9 until about 9:15?
Yeah.
And during this conversation, without telling us the substance of the conversation, did you and Mr. Simpson make any plans to get together later in that week?
Yeah, we talked about getting
No,
together.
that's not here, so you can answer yes or no, yeah.
Yes or no?
Yes.
All right, you made some plans?
Yeah.
And, Doctor, what date, if any, were you going to get together after that date?
Oral, you can answer the question.
The following Wednesday.
All right. And on the following Wednesday, which would be, I guess, Wednesday, June 15th, what were you and Mr. Simpson going to do?
We were going to go and have dinner.
Oral,
What were you going to do, sir?
We were going to go and have dinner
And that would have been where, in what city?
in LA. He was going to come back and we're going to have dinner.
Now, with regard, you've described for this jury Mr. Simpson's voice of how he sounded, more relaxed and upbeat during this conversation. Did that voice ever change at all during this conversation?
No, it was a very friendly, very open, happy conversation.
It's a happy conversation? Is that yes?
Yeah.
Thank you very kindly, Dr. Recker.
Darden,
Have one moment.
certainly.
Good morning, sir.
Good morning.
You consider yourself a close friend of the defendants?
Yes, I would.
And you say you met him in early summer 1993, is that correct?
That's correct.
You consider yourself the defendant's best friend?
No.
You and he have gone to dinner on many occasions?
Yeah.
He's taken you to dinner? So you have to answer out loud.
Yes.
Okay. He's taken you on vacation?
Yes.
Took you to Cabo San Lucas?
Yes.
He paid for the trip?
Yes, he did.
Did he take you to Aspen?
Nope.
Take you anywhere else on any other vacation?
Nope.
When were you taken to Cabo San Lucas?
In Easter 94.
How long were you there?
I was there for 4 days.
Okay, and that's down in Mexico?
That's correct.
You also knew Nicole?
Absolutely. I knew Nicole first.
I'm sorry?
I knew Nicole first.
She was also a close friend of yours?
I would say so, yeah.
Okay. When you told us that you had heard the well, when you told us that the defendant sounded jovial and more relaxed than he had in several months. By the way, was that your testimony, that he
Yes.
sounded more relaxed than he had in several months?
Yeah.
And he hadn't been relaxed over the prior several months, is that correct? Is that correct?
Could you repeat the question?
Well, he hadn't seemed very particularly relaxed over the prior months, is that correct?
Yeah.
Is that correct?
That he seemed more relaxed that evening than previously?
Yes.
Yes.
And that's because during the weeks leading up to that phone call, the defendant had been depressed because of his failing relationship with Nicole Brown. Is that correct?
I wouldn't say depressed.
Well, have you ever described to anyone the defendant having been depressed?
At times, but he wasn't depressed all the time.
Well, during the weeks leading up to this phone call, did the defendant, in your opinion, seem depressed over his failing relationship with Nicole Brown?
At times, yes.
In fact, he seemed upset. He was upset with Nicole Brown during the weeks leading up to that phone call. Is that correct?
At times, yes.
And he was upset because Nicole Brown didn't want to see him any longer. Is that correct?
No, that's not correct.
You were interviewed by the LAPD on June 23, 1994. Is that correct?
Uh-huh, yeah.
You spoke with the officers about the defendant and his relationship with Nicole Brown?
Right.
Did you tell the officers that the defendant had been upset because Nicole Brown had changed her mind about having a relationship with him?
She changed her mind frequently about having a relationship with him or not having a relationship with him, and that's what he was upset about.
Now, please listen to my question carefully.
I am.
Okay. By the way, are you here to help the defendant?
Object before that question. I did testify.
Oh, you here to help the defendant?
Nope.
Did you tell the officers that the defendant was upset because Nicole had changed her mind about having a relationship with him?
I object before that question. I'd like to
Been asked, that question was already asked and answered.
Well, it wasn't answered.
Let me see counsel sidebar with court board, please. All right, thank you, counsel. Proceed. I think Mr. Darden was asking the question regarding the changing of the mind.
In fact, the defendant and Nicole Brown, they had an off and on relationship on a number of occasions. Is that correct?
That's correct.
Sometimes she broke up with him.
That's correct.
Sometimes he broke up with her.
Yep.
And it went like that for a couple of years. Isn't that right?
As the last year and a half that I was privy to, that's
The
correct.
defendant gave Nicole Brown an expensive gift for her birthday in May 1994. Is that correct?
Yeah.
She returned that gift to him.
Yes, she did.
And he had given her some earrings on an earlier occasion. Is that right?
I don't know yet.
Sustained.
You know what date it was, the date that Nicole Brown decided finally that she would no longer have a relationship with the defendant?
I object to call that question. So the fact not having it.
Sustained.
You told us a few moments ago that Nicole Brown was also your friend. Is that correct?
That's correct.
Is it your opinion, Dr. Reichart, that Nicole Brown deserved to have had her throat cut?
Sustained. 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 It's not an appropriate question, Mr. Darden. Have a seat, Mr. Cochran. Not an appropriate question.
Can I be heard at sidebar with discovery, Your Honor?
Discovery? It's not an
There
appropriate
was a
question.
1054 submission to the court on that issue, as I recall.
With the court order. All right, thank you, counsel. Mr. Darden, you may continue.
Mr. Reichard, Candace Garvey was a patient of yours, is that correct?
That's correct.
Okay. She is someone that you treated during the first week of July 1994?
Sustained.
Were you planning to somehow make some money off of this case, doctor?
Oh,
You were planning to write a book, weren't you?
that's correct. A book on personal ethics.
You were planning to write a book about Nicole Brown.
No,
You were planning to write a book about the defendant and Nicole Brown.
no,
You're planning to write a book about what you knew about the defendant's relationship with Nicole Brown.
no,
And you were planning to have a co-author on that book?
excuse me?
Were you planning to have a co-author on that book?
Absolutely not.
Isn't it true that you told Candace Garvey that you
Overruled.
Isn't it true that you told Candace Garvey that you're going to do a book, write a book regarding Nicole Brown?
That's not correct.
Did you ever visit a lawyer, speak to a lawyer about writing a book?
No,
The first time that you were interviewed by the prosecution was what, June 23? I'm sorry, by LAPD was June 23, 1994?
yeah, about a week and a half after the murder.
And had you prior to that agreed with someone else that you would not speak to the police regarding any information you had regarding the defendant and his relationship with Nicole Brown?
Overruled. Do you understand the question, doctor?
Could you repeat the question?
Okay. Well, had you and some other person agreed that you would not speak to the LAPD or the prosecution regarding any information you had regarding the defendant?
I had made an agreement to not talk to the media, but do whatever is required by the court.
Okay, so you had no agreement not to talk to the DA's office.
No,
You had no agreement not to talk to the LAPD.
no,
But didn't you tell Candace Garvey both of those things, that you had an agreement with someone else that you would not speak to the police or the DA's office?
Overruled. 770 and 1235, counsel.
I had an agreement to not talk
Could
to
you
the
please
media.
answer my question, yes or no?
No, wait. Let him finish answering the question.
Please, sir.
I had an agreement to not talk to the media.
So is the
That's
answer
it.
to my question no?
No, I did not have an agreement to not talk to the LAPD.
Now, the conversation you had with the defendant, the conversation you say you had the night of June 12th, is that yes?
Yes,
Do you have a phone record to indicate the time of that phone call?
I don't have one. Mr. Simpson called me.
Okay, do you have a phone bill that'll indicate the time of that phone call?
I don't think it would show up on my phone bill.
Okay, do you have any record at all that will establish the time of that phone call?
I'm sure it could be established if Mr. Simpson's phone records would be checked.
Well, have you seen any record that'll establish the time of that phone call?
No, I haven't.
Have you seen any record that will establish that that phone call ever took place?
No, I haven't.
You say you were alone in your home when you received this telephone call,
That's correct.
and you say it was approximately 9 o'clock.
That's correct.
Okay, you're not sure of the exact time?
About 9 o'clock.
Could be earlier, could be later.
Give or take a few minutes because I looked at the clock.
You also looked at the clock.
Overruled.
You're also the defendant's chiropractor, is that right?
I've seen it as a friend, yeah, not a formal business arrangement.
Okay. You've treated him
Yes,
for free?
yeah, absolutely.
Now, this telephone call you say you received from the defendant about 9 o'clock that Sunday night, how long did the call last?
I'd say approximately 15 minutes.
15 minutes. Is that what you told the LAPD when they interviewed you back on June 23?
I believe so.
Have you seen your statement?
Excuse me?
Have you seen your statement to the LAPD?
No, I have not.
And so you received this call and it seemed jovial and relaxed, more relaxed, right?
That's correct.
Had you spoken to him the day before at all?
No, I haven't.
How about the day before that?
No, I haven't.
The day before that?
No, I haven't.
Had you spoken to him at all during the 7 days prior to Nicole Brown's murder?
No, I haven't.
Okay. How about during the 2-week period prior to the murders? Had you spoken to the defendant?
I talked to him about 10 days prior.
And that was after the defendant broke up with Nicole Brown?
I think that was still at the time we were trying to figure out what to do.
And he seemed depressed and upset at that time.
He seemed upset at the time when he was going to go out of town.
Now, given the fact that you didn't speak to the defendant for another 10 days, you can't tell us then what his demeanor was like during that 10-day period leading up to that phone call. Is that correct?
No, I cannot.
And you can't tell us what the defendant's demeanor was after he hung up the telephone with you. Is that
No, I
correct?
cannot.
You can't tell us whether or not he was putting on an act of faking when he called you at approximately 9 o'clock.
Rephrase the question.
You understand that the defendant is an actor, correct?
Overruled? Overruled.
Yes, I do.
Has he had any formal training that you know of?
Not that I know of.
Have you ever discussed that issue with him?
No.
Can you tell us whether or not he was acting or putting on an act when you spoke to him on the telephone?
Can one ever?
Pardon?
Can one ever? How would I know?
Well, you know him.
Yeah, I mean, to me, he was not acting. Can I
To you, he
prove it?
wasn't acting.
Excuse me?
To you, he wasn't acting.
Nope.
So you can tell then.
Argumentative? Rephrase the question.
Would you agree that a person, a perfect stranger who didn't know the defendant before would have trouble telling if he was acting?
Sustain.
You can't tell us whether or not the defendant was cut at 9:15 or 9 o'clock, can you?
You didn't see him physically on that date, did you?
No, I did not.
All right, that's the only testimony that's in the record, counsel.
Did the defendant tell you what he was wearing at the time?
Nope.
Overruled.
Tell you whether or not he had a pair of gloves with him at the time?
Overruled.
Now, you and the defendant, you plan to go into business together. Is that right?
That's not right.
Well, you had had a prototype of a certain exercise contraption made. Is that correct?
That's correct.
And what was this contraption called? Or did it have a name?
We hadn't given it a name yet. We're going to call it something like the Exerciser or something like that.
Or the Porta Gym or something like that?
Porta Gym. Yeah, it was like one of the names that we flew around. Yeah.
Okay, and when did you have that prototype made?
That was in February '94.
And you and the defendant had discussed producing this item, hadn't you?
Overruled.
If the video would be a success, and that was a possibility.
Okay, so my question is, you and the defendant had discussed producing this particular item, is that correct?
Possibly, yeah.
Okay.
We had discussed to possibly produce it, item.
Will you possibly discuss something? You had possibly discussed?
No, we discussed to possibly produce the item.
Okay. You discussed producing the item prior to your having the prototype made, is that right?
Yeah,
Okay. And you did have the prototype made in February 94. Is
for
that
the
correct?
video. That's correct.
And you were going to include that exercise gadget or contraption with the video that you say that you and he were going to produce for Playboy. Is that correct?
We weren't the ones making that decision. Playboy would be the one making that decision.
Okay, but you were going to offer or suggest to Playboy that they include your exercise gadget along with the video?
That's correct.
Now, I take it you weren't going to give this exerciser to Playboy for free. Is that correct?
That's correct.
You and the defendant were going to manufacture these items, correct?
If Playboy would accept it, yeah.
Okay, and you were going to sell them to Playboy. Is that correct?
Yeah.
Now, in May and June of 1994, you and the defendant were planning to manufacture 100,000 units of this prototype. Is that correct?
Possibly. Yeah, if it would be included in the video.
Okay. Well, you were discussing the production of 100,000 of these units.
Yeah, not the defendant and I, actually the person that helped me manufacture it, yes.
Okay. But you and the defendant were discussing the production of these as well, correct?
Yeah, but not of 100,000 pieces.
The defendant was going to kick in some money into the project?
No,
You never discussed with the defendant him putting up money
No.
for this project?
no. I was going to put up money.
You were going to put up the money to produce 100,000 units.
Yes.
And you had that kind of money.
Sustained.
Did you have that kind of money, sir?
Sustained.
We wouldn't have made up.
Sustained.
Okay.
Well, have you produced this item?
No.
In fact, you were talking to someone about producing this item all the way up to the last week before Nicole Brown's murder. Is that correct?
Probably, yeah.
You were speaking to someone about producing this item up until the defendant's arrest, correct?
I don't recall.
But close to that day.
Probably.
Okay. But you haven't discussed it with that person since the defendant's arrest, have you?
I've thought about it, yeah.
You've thought about it,
Absolutely.
but you haven't discussed it with the person who produced.
Nope.
So the project is no longer viable. That is without the defendant. Is that correct?
Overall. But we are going about at the end of it.
Okay. When you spoke to the defendant that night, he asked you about Nicole, didn't he?
Actually, no.
The defendant didn't ask you if you'd heard from Nicole?
Objection, Your Honor. Hearsay.
Overall.
Did the
What is-
defendant ask you during that telephone conversation if you had heard from
I
Nicole?
don't believe so.
Let me show you a copy of a statement.
Have you shown this to Mr. Cochran?
Mr. Cochran has a copy of it.
Mr. Dart, I want you to
Page 2, paragraph.
show also Mr. Rubikov if you have an extra copy. Counsel, once you step over to the podium here, confer with each other, then show Mr. Rubikava, please.
Let me show you a copy of a statement prepared by the LAPD where it contains your comments to them on June 23, 1994. I'd ask you to look at paragraph 2, page 2.
All right, witness nodding affirmatively. Mr. Dart.
Does that refresh your recollection, sir?
Yeah, I mean, obviously the focus of the conversation was not about the call, so
Okay. Well,
I'm,
did the defendant ask you during that phone conversation whether or not you'd heard from Nicole
I don't
Brown?
recall right now, but as it is there in the paper, probably did.
But you don't recall now.
No.
By the way, let me ask you to read the statement. And let me ask you if anywhere in the statement did you tell the LAPD that the conversation lasted 15 minutes?
Overruled. Overruled.
And your question was, could you repeat it again?
Does the statement indicate that you told the police that you spoke to the defendant for 15 minutes?
Nope. Overruled. Overruled.
I object to the speaking objection. Did you read the complete statement, by the way?
Did I ever read no, I never
sorry,
received the statement.
My question is, did you read this complete statement just now? Did you
I
read
glanced over it, yeah.
Okay, you feel like you're familiar with what's contained therein? I mean, you have a grasp of it?
Yeah.
Okay,
Kind
seems accurate to you?
In order to be accurate, I'd have to read it more in detail. I just trying to see whether somewhere it said I talked to him for 15 minutes.
After the defendant and Nicole Brown broke up, did the defendant tell you that he was concerned that she was seeing someone else?
Yeah.
Overruled.
Yeah.
And this was during that time period in which he was upset and depressed, is that right?
Overruled.
Is that correct?
I don't. Could you repeat the question?
This is during that same time period in which the defendant was both upset and depressed at having broken up with Nicole.
Yeah.
And this will be during the end of May, is that correct?
That's correct.
At about the same time that she returned the jewelry to him, correct?
I don't know exactly when she returned the jewelry to him.
Do you know what the defendant did with the bracelet after Nicole Brown gave it to him?
Sustain.
I have no idea.
That's all I remember.
Mr. Cochran.
Dr. Reichard, Mr. Darden asked you some questions, and he didn't finish asking the questions about the statement. Have you ever first?
Excuse me, counsel.
Well,
Let's
let me
rephrase that.
Okay, I'll rephrase it. With regard to this alleged statement that was reported by the Los Angeles Police Department on June 13th, 1994, from June 13th, 1994, do you recall talking to the police at some time after June 13th?
Yes, I do.
And were you cooperative when you talked to them?
Absolutely, yeah.
All right. And in that statement to the police, you told them that about this conversation with Mr. OJ Simpson, isn't that correct?
Yes, that's right.
You told them that Mr. Simpson was packing for his trip to Chicago, that he returned on Wednesday, isn't that correct?
That's correct.
Just like you told this jury, right?
Right.
And that they would get together when he returned,
That's correct.
just like you told this jury, right?
Absolutely.
Do you?
You could just ask him about his testimony or about the statement, but what he's doing in front of the jury's here to observe that.
Thank you, Your Honor. Now, do you recall in this conversation whether or not this police officer, by the way, was that a telephone conversation that you had with the LAPD? The conversation over the phone?
I mean,
No, that was-
phone
they-
interview.
Was it a phone interview?
They came to my office.
Okay. And you sat and talked with them, right?
Absolutely,
All
yeah.
right. Do you recall them ever asking you how long your conversation with Mr. O.J. Simpson was?
Nope.
All right.
I don't recall.
But as you sit here now, you recall how long that was, don't you?
Absolutely.
It was 15 minutes?
Yeah,
And if they had asked you, you would have told them 15 minutes, right?
absolutely.
Now, with regard to the statement about whether or not you talked about Miss Nicole Brown Simpson, that was not the thrust of any of that conversation, was it?
Not at all.
In fact, do you recall that Mr. Simpson had said that to you that he was out of the loop, that he was glad to be out of the loop, and that he had gotten his life together with his new lady? Remember him telling you that?
That's correct.
And who was that new lady?
Paula Barbieri?
And you knew about Paula Barbieri, isn't that correct?
Yes, I did.
Also, Mr. Simpson had told you that he began dating Paula Barbieri on a regular basis, isn't that correct?
Yeah,
And that you had said and indicated to the police in the interview that Mr. Simpson seemed to like Paula a lot and seemed happy, or at least happier than he'd been before once he was with Paula. Isn't that
that's
correct?
correct. Yeah,
And that's what you told the police, isn't that correct?
yeah,
And when you talked to the police, Dr. Reichart, were you telling them the truth?
absolutely.
And you're coming here today to testify to this jury. Are you telling them the truth?
Absolutely.
Now, Mr. Darden asked you some questions about treating Mr. Simpson, and you said yes, you did. You recall that?
Yeah.
And what did you treat Mr. Simpson for? You open the door. What did you treat him for?
For his knee problems,
And what knee problems are those?
I observed him one day in the morning walking down the stairs, and that he had
He can answer. Please.
that he had a very hard time walking, and I said, "Come on, and we'll start taking care of that."
And when was that?
Must have been also early summer '93,
And how long did you take care of him for his knee problems?
sporadically when he was in town.
And did that continue on into 1994?
Absolutely, yeah.
Mr. Darden asked you about writing a book. Do you have any plans? Have you ever tried to profit one iota on this case, sir?
I refused to.
And every time the district attorney's office has asked you to come down and talk with them, you've talked with them. Is that correct?
That's correct.
In fact, you did a rather lengthy interview with Mr. Darden himself. Is that correct?
That's right.
At some point. Is that right?
Yeah.
You came down voluntarily and talked to him?
He came to Mr. Rubalcava's office.
And you talked to him?
Yeah.
With regard to these trips, you and Mr. Simpson were friends. Is that correct?
That's correct.
And you've been on various trips together?
That's correct.
Been out dinner together?
That's correct.
And back in 1993, when you first had occasion to meet Mr. OJ Simpson, at that time, was he seeing Miss Nicole Brown Simpson at the point? Were they together?
They were trying to see whether it would work out or not.
And who was pursuing who at that point, if you recall?
At that time, Nicole was trying to put a family together.
Well, overruled. She was trying to get back with him?
Right, to have a family for her children.
Have just a moment, Your Honor. Dr. Reichart, when you would go on trips with Mr. Simpson, you'd pay your own way, would you not?
Yeah, at times.
All right. And would sometimes Mr. Simpson provide lodging or rent a house or a villa for everyone?
That's correct.
And you'd pay your own way to get there?
For the plane tickets, yeah.
You'd pay your own. All right.
and food and things like that.
Now, with regard to your knowledge of Mr. Cole Brown Simpson and Mrs. Simpson, you've described for us that Mr. Darden asked you a question about at some point they stopped seeing each other and that Mr. Simpson started seeing Paula Barberi. You recall that?
Yeah.
And
Excuse me. Overruled.
And was there a time when you were aware of, was there ever an argument where Ms. Nicole Brown Simpson called you up and argued with you about after she'd broken up with Mr. Simpson, or they had broken up?
Yes, there was.
It had to do with your going. Oh, he's
Sustained.
opened the door, yeah.
Not to a statement by somebody else.
Well, I didn't ask the statement. I didn't ask the statement yet. May I ask another question?
Proceed.
Thank you, Your Honor. Was there an occasion when Mr. Simpson started to date Paula Barberi that Mr. Cole Brown Simpson became upset, and then there was a conversation that you received a telephone call from her?
Sustained. That's your statement. Wait, that's also a speaking objection. You're not standing either, counsel. Sustained.
Thank you. I have nothing further at this point, Chairman. Thank you very much.
Thank you, Mr.
Thank you,
Carter.
Doctor.
Your Honor.
Recross, Mr. Darden.
Thank you, Your Honor. Mr. Reichardt, was the defendant dating Nicole and Paula at the same time?
I don't believe so.
Do you know that for a fact?
I don't know that for a fact.
Now, in talking to you about Nicole Brown, isn't it true that on many occasions that you and the defendant would often talk about the problems the defendant was having with Nicole Brown?
Sustained. It's vague.
Okay. Well, you and the defendant would go out on occasion, right?
That's correct.
And on those occasions, you and he would talk about your respective relationships, correct?
Overruled.
Correct?
That's correct.
And he would talk to you about his relationship with Nicole Brown, is that correct?
That's correct.
And he told you how hard he had been trying to make Nicole Brown happy, is that correct?
Overruled. Overruled.
He told you how hard he had been trying to make Nicole Brown happy, is that correct?
That's correct.
And he told you that she wasn't happy in that relationship, didn't he?
At times, yeah.
In fact, this was a recurring theme in conversations you had with the defendant, wasn't it?
That's correct.
Overruled.
Now, you told us a moment ago that you treated the defendant for his knee. Is that correct?
That's right.
Okay, you're not a medical doctor.
No, I'm not.
You saw the defendant and you felt he had a problem with his knee.
It was pretty obvious, yeah.
Okay. But you didn't stop him from doing that exercise video in late May 1994, did you?
Nope.
Overruled.
Were you present during the shooting of that video?
No, I wasn't.
Overruled.
You weren't present at that video shooting to make sure the defendant didn't injure himself?
He's already indicated he wasn't there.
No, I wasn't there.
Did you ask to be there so that you could...
Sustained. Sustained.
Are you, strike that. Do you know a woman named Gretchen Stockdale?
This is beyond the scope of everything.
Overruled.
I don't believe so.
Okay. Were you ever introduced by the defendant to a woman who was a lingerie model for Victoria's Secret?
Sustained. Sustained.
Okay. To the best of your knowledge, was the defendant seeing anyone else during May 1994, that is, other than Nicole Brown and Paula Barbieri?
Overruled.
Can you repeat the question?
Was the defendant seeing anyone else, any other woman, during May 1994, in addition to Paula Barbieri or Nicole Brown Simpson?
Not that I know of.
Thank you.
Dr. Reichart, there were occasions when you and your lady friend would go out and double date with Nicole Brown Simpson and Mr. Simpson. Is that correct?
That's correct.
And on occasions, and who was your girlfriend?
Faye Resnick.
And on occasion, would you talk, would the four of you talk about domestic matters?
Absolutely.
All right. And on occasions, as I understand what you've told this jury, as with all couples, there were times when Miss Nicole Brown Simpson wanted to get back with the family, right?
That's correct.
And and there were times when Mr. Simpson wanted to get back. Is that correct?
That's correct.
And they tried to get together and make it. Is that correct?
Yeah,
And they didn't make it. Isn't that correct?
they didn't make it.
And after they didn't make it, you became aware that Mr. Simpson was seeing Paula Barbieri. Isn't that correct?
That's correct.
And he seemed happy and more relaxed, right?
That's right.
That's what you told us here today, right?
Yeah.
Thank you, sir. Thank you for coming. Nothing further.
You also told us that Nicole Brown cut that relationship off, didn't she?
Jackie, it's not object to the point.
It was Nicole Brown Simpson that left the defendant and not the other way around. Isn't that correct? Isn't that correct, Dr. Reichart?
I think they went through difficult times and they,
Dr. Reichart, isn't that correct?
He can answer the question.
It was Nicole Brown Simpson that broke up with the defendant, correct?
Overruled. Just answer the question, Doctor.
I don't think it's a question that could be answered with yes or no.
Thank you.
And after that occasion, after that occurred, the defendant was depressed and he was upset about it, right?
I think at the time when they both mutually figured out it's not going to work, yeah, they both were depressed.
Anything more, Mr. Darden?
Dr. Reichart, kind of unusual that after a 17 or 18-year relationship finally ended, that both of the parties might feel a little bit down. Oh, John, where's the doctor? It's like, how
Oh,
John is speaking.
oh.
Did you find that unusual?
I don't find that unusual at all.
In fact, you find that quite normal, Doctor?
They have 2 children and yeah, I find it quite normal.
Thank you, Doctor.
Do you profess to be some doctor of love now, Dr. Reichart?
Object, Your Honor. That's
Sustained. Sustained. Counsel, we have to remember that we have an intelligent jury here.
Okay.
They have common sense with human experiences.
I'd like to ask the witness about a psychological term, may I?
You may.
Have you ever heard of estrangement rage theory?
Nope.
Never read about that.
Nope.
Thank you.
All right, Doctor, thank you very much. You're welcome. All right, you're excused. Mr. Rubalcaba, thank you, sir. All right, next witness.
Yes, Your Honor.
Let me just inquire. Anybody need a comfort break? All right, while you're getting your next witness, we'll just excuse you quickly. All right, let me see, counsel, lift court reporter, please. Well, the court with his counsel, the people are represented, the jury is not present. We also have counsel, Mr. Weitzman and Mr. Tarlow present. Mr. Cochran, you had something to bring to the court's attention.
Yes, I do, Your Honor. Good morning again, Your Honor. We have had, during this break, an opportunity to talk to Mr. Weitzman, who's come here today, and I thank him and his counsel, Mr. Tarlow, for doing that. He is willing to testify. We've conferred with Your Honor and actually with Mr. Simpson. And we've decided at this point not to call Mr. Weitzman. He's available to testify if we need him. We don't think it's necessary at this point, and if it becomes necessary later, he will come back. And we thank him for coming.
We'll know where to find him.
Well, yes, I think we can now find him, yes.
Okay.
And he
Your
was-
Honor, my lead have the subpoena for and he'll be available through either his office or mine.
Yeah,
Well,
that's fine
upon
with
your
us.
representation, counsel, that you'll make him available upon reasonable notice, I'll accept that.
That'll be fine. Thank you.
Thank you, Judge.
And thank you, gentlemen, for coming. We're ready with the next witness will be Mr. Barris, Your Honor.
All right, then I suggest we take our recess for the lunch hour then, at this point.
That's fine, Judge.
All right, you had
One other question. With regard to the Menzione, the court knows that we'll have Barris, then we would like to resolve the matter of Menzione before Dr. Lee testifies because it'll be determinative of whether we have her come out. So at some point, you're going to let us argue that. Ms. Sean Chapman will argue that.
All right, I'll be delighted to hear the argument.
Remember, we're this close. You recall that.
I recall
All right.
that.
So let us know when to do that, Judge. Thank you.
All right, I anticipate doing that sometime this afternoon then.
It's just the shot.
I understand that. All right, anything else before we stand in recess? Did you want to take care of that one other issue?
Oh, yes, Mr. Klein.
Mr. Douglas?
Yeah, Mr. Douglas would like to approach and do it at sidebar, if at all possible. I'll have to step in though first, before that. That'll be back.
So you know, just like, go to the next one, is that after the hotel, with the barracks, and then we will go. Isn't it late? So then we have a couple of issues to open, we'll step in.
I understand that. All right, Mr. Douglas is also present with Mr. Klein Allen, who was present and ordered back to return today. Mr. Douglas, what's your pleasure?
I'd like to put you on command.
All right, with court board, please.
And Phil.
All right, counsel, as far as the court session is concerned, we'll stand in recess until 1:30. Mr. Allen, I'm going to ask you to remain to consult with counsel for a few moments, all right, after we've cleared for the day. Excuse me, for the morning. All right, we'll reconvene at 1:30. All right, I'll be in chambers, counsel. Jury is not present. Mr. Darden, are you going to handle Mr. Lee, or is Mr. Goldberg?
Who's next? Mr. Harris.
Mr. Barris, all right?
Well, I'm going to handle Mr. Barrett.
All right.
Way down the elevator.
I'm sorry? You ready? All right, Deputy Magnaro, let's have,
I'd like to approach this in 1 minute here. Excuse me, Porter.
what is that?
1 minute, I'd like to. Stay here.
All right. What do we have to do at the sidebar? We don't have a jury.
Sidebar. Yes,
With the court reporter.
I saw that.
All right, Deputy McNair, let's have the juror, please. Gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And Mr. Cochran, you may call your next witness.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. We'll next be calling Detective Ken Burris to the stand. Detective Burris?
Raise your right hand, please. You do solemnly swear that the testimony you may give in the trial counsel before this court should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please have a seat in the witness stand and state your first and last name for the record.
All right, why don't you pull the microphone close to you? There you go. Thank you.
Yes, my name is Kenneth Beers. My last name is spelled Berris.
Good afternoon, Mr. Burris.
Good afternoon.
And what is your occupation, sir?
I'm a detective assigned to Area 5 Detective Division, Chicago Police Department.
And how long have you been so employed, sir?
I've been a police officer over 26 years and a detective over 18 years.
In that connection, have you come here today to be with us here in California to pursuant to subpoena issued by this court?
Yes, sir, I am.
And you arrived in Los Angeles when?
Last night.
First time you and I have had an occasion to talk was when?
Earlier today, this morning.
All right, I'd like, sir, to direct your attention back to the date of Monday, June 13th of 1994. Do you recall that date?
Yes, sir, I do.
At some time in the morning hours of June 13th, were you assigned some duties in connection with the O'Hare Plaza Hotel in Chicago, Illinois?
Yes, I was.
Approximately what time did you get a call or were you assigned some particular duty?
At approximately 11 o'clock in the morning on that date, myself and Detective Anthony Bongiorno, if you'd like, I'll spell his last name.
Please.
Of course. Bongiorno. He's also assigned to Area 5 Detective Division, where I am also assigned. We were assigned to go to the O'Hare Plaza Hotel by Sergeant Vernis Jones, a supervising sergeant in our unit.
All right. And thereafter, after you and Detective Bongiorno were assigned to this particular hotel, what time, if you recall, did you arrive at the O'Hare Plaza Hotel?
We arrived shortly after 12 noon.
And is that, would I be correct in assuming that that hotel is near the airport in Chicago?
Yes, it's nearby.
All right. And when you arrived there at the hotel around 12 noon, did you have occasion to go and speak with a general manager at that hotel?
Yes, we did.
Without telling us the conversation at that point, tell us the name of that general manager, sir.
Mr. Peter Phillips.
All right. And did you and your partner officer have occasion to talk to Peter Phillips?
Yes, we did.
All right. And how long did that conversation last, sir?
Oh, approximately half an hour.
All right. And during the course of that conversation, did you obtain some information about a room 915 in the O'Hare Plaza Hotel? You can answer that yes or no.
Yes, we did.
And were you able to ascertain whether or not that room had been secured that morning prior to your arrival?
Yes, it had been.
All right. And thereafter, at some point, did you and your partner have occasion to go up to room 915?
Yes, Detective Bongiorno and I, accompanied by Mr. Phillips, went to room 915.
And when you got there, did you have a key to that room?
Mr. Phillips had a key.
All right. And so when you describe for the jury what kind of a key did you have for that particular room?
It was a what I might refer to as a card key. It's put into a slot. It's a card coded, and it's put into a slot, and the code unlocks the door.
All right. And are those the kind of doors that have some kind of little computer in them?
Yes, I think that would be a fair description.
Let me see if I can give a word picture. You slide the little card into it, and the little green light comes on. Push the handle, and the door opens up. Is that right?
Yes.
All right. So that's what happened with Mr. Phillips. Is that correct?
Yes.
And what time was that when you did that?
I would approximate that to be between 1:30 and 1:45 in the afternoon.
Now, with regard to that particular room, did you ever have occasion to check to see whether or not there was, in fact, a computer that would tell the number of times anyone had entered that room on June 13th, 1994?
I never determined anything like that there was such a computer as part of the locking device.
Okay. At any rate, you gained entrance in there sometime around 1:30 to 1:45.
Yes, sir.
And who went inside the room at that time, if anyone?
Myself, Detective Bongiorno, and Mr. Phillips.
All right. At that time, sir, did you have occasion to look around and look inside the room?
Yes, we visually inspected the room.
Okay. And how long would you say you stayed in the room at that time?
Oh, approximately 20 minutes or so.
All right. Did you pick anything up at that time at all?
No.
All right. You just had a visual observation of the room. Is that correct?
Yes, sir.
And would I be correct in assuming that there was no one in that room at that point?
No, when we arrived, there was nobody in the room.
And with regard to the bed in the room, did the bed appear as though someone had slept in that bed the night before?
Yes, the bed wasn't made. The covers were tossed back as if someone had been sleeping in the bed.
All right. And so the bed hadn't been made by the maids at that point. Is that correct, sir? The best you could tell?
I'm sorry,
I said the bed had not been made by...
Oh, it had not been made. That's
Okay.
correct.
All right. Now, you told us that you stayed in there approximately a half hour, and then did there come a time when you then left and went someplace else to make a phone call?
Yes, the three of us, myself, Detective Bongiorno, and Mr. Phillips, left the room, or mini suite of rooms, if you will. The room was secured and locked, and we then went to Mr. Phillips' office, where I called our crime lab, the Chicago Police Department crime lab, and requested crime lab technicians to come to that location.
All right. And about what time was this now, sir?
I made that call between 2 and 2:15, I would estimate.
All right. And you requested some crime lab technicians.
Yes.
And did there come a time when the crime lab technicians arrived at the hotel?
Yes.
And approximately what time was that?
3 o'clock in the afternoon.
So by 3 o'clock then on June 13th, 1994, the crime lab technicians arrived. And tell the jury their names, sir, please.
Crime lab technicians John Stella, Stella, and crime lab technician John Naujokis, Naujokas. They responded to their location.
All right. And who went back up to room 915, if anyone at that point?
Myself, Detective Bongiorno, the two crime lab technicians, and Mr. Phillips.
All right, sir. Now, I want you to just describe generally for the jury in brief fashion how this room was laid out, the hotel room. Can you do that for us?
Yes. Room 915 could be described as actually a mini suite of rooms, if you will. It consists of a living dining area combination. After passing through a doorway, you would be in the bedroom of the suite, and then passing through another doorway, you would be in the bathroom of the suite.
All right. When the first time when you were there with Mr. Phillips, did you ever go in the bedroom the first time?
Oh yes, we had gone into all of the rooms.
And the bathroom also, is that right?
Yes, sir.
All right. When you went back this second time with Najokas and Stella, the criminalist, was Mr. Phillips accompanying you at that point?
Yes, he was.
All right.
However, he did stay in the living dining area with Detective Bongiorno.
All right. So there were like 5 of you, is that correct?
Yes, sir.
All right. And when you went back in, you described for the jury this particular room. At some point, I think you've described for us the bed appeared as though it was unmade still. Is that correct?
Yes.
All right. And then you had occasion, did you not, to go into the bathroom area, that suite of rooms. Is that correct?
Yes, sir.
And in that bathroom area, did you have occasion to see? Let me seek to rephrase that, Your Honor. Okay. In the bathroom area, can you describe for the jury what, if anything, you saw in the sink of the bathroom area there of Suite 915?
In the basin of the sink was a broken drinking glass. Yeah, it was a clear glass that was broken and in the base of the sink,
All right.
along with a paper doily that those are usually on top of the glass when they're in the room.
Okay. And this glass was inside in the sink in the basin area, right?
In the basin.
Did you see any other remnants or shards of this glass on the so-called vanity area in and around the sink?
Yes, there were at different locations along the vanity several small, and I'll describe them as chips because they were very small, of broken glass.
All right. And now what about towels? Did you see any large towels in this same general area near the sink basin area?
Yes, on atop of the vanity, directly to the right of the wash basin, was a towel that was not folded. It appeared to have been used. It was wrinkled and left on top of the vanity to the right of the basin.
And did you have occasion to lift that towel up at some point?
I didn't.
Did the technicians lift that towel up at some point?
Yes, when in the course of their processing that scene.
And when the towel was lifted up, did you have occasion to see a washcloth or a face cloth?
Yes, I did.
Describe for the jury what you saw with regard to this washcloth or face cloth.
That washcloth had a reddish stain on it, which I suspected to be blood.
All right, and describe for us how you saw that washcloth or face cloth.
It was, it was underneath the towel. It's the best I could describe it, to the right of the sink bowl. When I initially had gone into the bathroom, I didn't see it since the towel was on top of it, concealing it from view.
All right, so would I be correct, Detective Barris, you couldn't see the smaller face cloth until the towel was lifted up by the technicians, is that correct?
That's correct.
All right. Now, with regard to the things you've just described for our jury, were there photographs taken of that bathroom area and the sink area, which might be illustrative of what you just talked about?
Yes, there were photographs taken of the entire mini suite.
Thank you. I want to show you. I'd like to show these to counsel. I'd like to show them witness a couple of these, if I might, and then I'll
Proceed.
on the Elmo. If I might. I want to show you what's first been marked. I think we marked these starting with 1331. Let's see. I want to place before you several photographs. Mr. Darden has seen these. I want to place before you defendant's 1331. And I want you to describe what's depicted in 1331, sir.
That is a photograph of the washcloth with the red stain on it, which was suspect blood, that was found to the right of the wash basin in the bathroom of that mini suite of rooms.
And is that a fair and accurate portrayal of the way that that washcloth appeared after it was removed, after the towel on top of it was removed?
Yes, sir.
All right. Then I'd like to place this on the Elmo, if I might.
You may.
I'll place the others before him also.
All right, this is 1331.
It's 1331, Your Honor. Thank you. And I'd like also to have Mr. Sheriff that too. We've blown up 1331, we have a 1331A also.
I think we need to clear the PowerPoint there. Be overruled.
Now, while Mr. Harris is moving 1331A in position, that's the way that particular face cloth looked after the towel had been on top of it had been moved. Is that correct, sir?
Yes, sir.
And you've seen 1331A also, have you not?
Are we still speaking of the washcloth, Mr. Harkin?
Have you seen this 1331A?
Oh, the large poster, yes.
Yes.
Yes, I have.
And 1331A is a blow-up of the photograph on the Elmo. Is that correct, sir?
Yes, sir.
All right, sir. I'd like to ask you in turn about the other photographs. Will you look at 1332 and tell us what's depicted in 1332?
In that photograph, it's a photograph of the wash basin and vanity of the bathroom in room 915. And it depicts in the basin the broken drinking glass and white doily cover. And atop the vanity to the right is the wrinkled towel, which was there upon our inspection.
And is that the towel you described for us earlier that had it covered the face cloth?
Yes, sir.
All right. I'll place this on the L. So 1332 is a fair and accurate portrayal of the way the large towel looked while it covered the smaller face cloth depicted in Appendix 1331. Is that correct?
Yes, sir.
Would it be better to describe that as a hand towel? Doesn't appear to be a bath towel size.
You're talking about the larger?
Yes.
I think that's fine. We call that a hand towel then?
I was just referring to it as a towel myself.
Well, the judge says call it a hand towel. I think we generally call it a hand towel.
I agree.
Let's call it a hand towel then.
Yes, sir.
Well, they give you three kinds of towels in a hotel. They give you washcloths, hand towels, and bath towels. These are experts on hotel towels.
And apparently so are you. So I'll go along with it.
And they know about those locks, too.
Okay. Thanks, Judge. Okay. With regard to, let's go quickly through this then. The hand towel was covering the face cloth. Is that right?
Yes, sir.
Okay. And to the left of that is the glass you've described, the broken glass that's in the face basin. Is that correct?
Yes, it is.
I want to put 1331 back up for just a moment and ask you a question. You had mentioned that there were some chips of glass. I want you to look at 1331 and point out to us, if you can, whether you can see some chip of glass to the left of, upper left of this particular face cloth.
Yes, that's one of the chips of glass that was on top of the vanity, yes.
You described that for us earlier.
Yes, sir.
And that's basically to the left and above the basin. Is that correct?
Yes, sir.
Okay. And moving along then, with regard to 1333, what's depicted in 1333?
That is a photograph of the wash basin in the bathroom, room 915, with the broken drinking glass inside the basin with the white doily cover.
All right, there's a doily, and the doily's fairly well depicted in there.
Yes, sir.
1333. What's the...
And hopefully can assist to identify the cause. Now, the term crime scene reconstruction, would it be fair to say that after looking at as much evidence as you can, crime scene reconstruction would involve trying to figure out what happened, how it happened, and the sequence of events?
Yes, in certain aspect, you're absolutely correct. Crime scene reconstruction just basically based on the physical evidence, result of study of physical evidence, analysis of physical evidence, and crime scene study. Try to put a piece of puzzle together to determine when did it happen, how did it happen, what did happen, where did it happen, so-called 6W. And of course, try to answer certain aspect of sequence of event.
Now, in this, are there degrees of reconstruction, complete versus partial and limited?
Yes.
Now, were you able to do a complete crime scene reconstruction in this case?
No.
Why not?
I cannot make a complete reconstruction for this case.
I'll check getting into anything beyond disqualifications at this point, Rob.
All right, actually, we're going to take a recess at this point. All right, ladies and gentlemen, we're going to take a brief recess at this time. Please remember all my admonitions to you. We'll be in recess for 15 minutes. All right, Dr. Lee, you can step down. Return in 15, please. Thank you. All parties are again present. The jury is not present. Counsel, in our discussions about the discovery issues earlier this afternoon, I was trying to rack my brain to recollect the occurrences during the 1054.7 hearing that Mr. Blazier reminds the court that we did conduct with regards to a substantial number of the issues here. I've just received from my court reporters a transcript of that proceeding, of one of those proceedings, and apparently my recollection is now refreshed that we had 3 such in-camera hearings within days of that particular hearing. I have not had the opportunity over the break to even, it's literally hot from the photocopier, so I have not had the opportunity to read this or refresh my recollection as to my discussions with Mr. Blazier with regards to this 1054.7. There are also 2 other transcripts that are being produced right now. So the problem I have is I'm not in a position to rule on discovery sanctions as to any of these items until I've had the opportunity to completely refresh my recollection by reading the transcript of the previous hearing.
There were also, the memo I referred to was also submitted to you at that time. I have it on my computer. I'll fax another copy to the court, but it should be in the file. I also submitted to you copies.
Well, here's the problem, counsel. It might have occurred to both parties here that I've been concentrating 100% of my efforts on another issue. So,
Sure.
But since we have this witness here, I'm now going to stop any work on Furman and turn all of my staff's attention to this issue because I've got to go through now this stack of reports and correlate it with the in-camera offer because, quite frankly, this happened in March, and I have no independent recollection of what occurred then.
Sure. I just want to make sure that you were aware of everything that was submitted because there's also copies of reports with excerpts that were turned over that were provided to you in sealed envelopes that you should have somewhere back there. So,
I know,
as well
I
as
have a
the
package of all sorts of things. The problem is, the issue is, when do I have the time to sit down and look at all this stuff? That's the issue. All right, Mr. Goldberg?
Your Honor, maybe just to inquire, we did not know about the in-camera hearing. At this point, can the people also have access to the transcript, since presumably, if Mr. Blazer's representation is that the materials that were discussed herein were discussed then, I think that we would be entitled to analysis they've been disclosed to us anyway, if that isn't the case.
You know, I don't know of any precedents regarding disclosure of 1054.7 hearings in the course of trial. Frankly, I've never heard of it. Doesn't say I won't do it, but I've just never heard of it before. Of course, there are a lot of things I've never heard of before. So we're sort of at a dilemma here, counsel. I haven't had time to read this. It was just given to me.
I'm very
Mr.
eager
Scheck?
to pursue his,
And I'm proposing to quit at 5:30 today.
I understand, but
All right.
there are two areas that I'd like to get into that I'll just demonstrate that they are in the court. I described them to Mr. Goldberg. He knows what this testimony is going to be from other sources anyhow. That's the one thing.
Now, I'm listening to Mr. Scheck, Mr. Cochran.
One issue that we wanted to go into was the next logical step was talking about steps in forensic examination. Now, this will involve what was done at the crime scene here in terms of recognizing evidence, some
Right,
discussion of that.
I get the point.
Okay.
Let me ask Mr. Goldberg, do you have any objection to the basic discussion of criminalistics?
I told Mr. Trent that it was simply a generic discussion such as certain portions of the testimony that we heard yesterday that I couldn't object on discovery grounds, but if he's going to then relate it back to the physical evidence in this case and his examination of what he saw of that evidence and what he didn't see and what he looked for and so on and so forth, and what he saw in the photographs and the like, and correlate this to his investigation or some larger issue, that does present the same discovery problem.
I mean, what we intend to get into is his assessment of what they looked for at the crime scene, what they preserved, how they documented, how they collected it, and how that affects the inability to do a complete reconstruction. So we're going to be talking about the facts of the case. We're very eager to talk about the facts of this case, but I can't.
Is this similar to what we heard from Mr. Regal yesterday?
Well, I think it's similar, but I think it's more pointed because it's going to be going into the specifics. Dr. Lee, as you can see, is going to be talking about nothing but evidence, physical evidence, and his assessment of it, and what we think are scientific facts and some matters of interpretation.
You
But
didn't
many
answer, but
scientific
my
facts.
question to you is, this is the same stuff that we heard from, isn't this chart exactly what we heard from Mr. Regal yesterday, only in different order?
Well, it's Dr. Lee's approach to it. It's similar. I'm not saying it isn't similar, but it's his approach. It's not that long. But it's what he needs to explain why he couldn't do a complete reconstruction, and to explain exactly what he could assess and what he couldn't assess, and what his problems are with the way they preserved, documented, and collected things. What
All right,
limitations
what's after
they
this?
placed. I'm sorry?
What's after this?
And then after that, I wanted to do is go directly to the issue of imprint evidence at Bundy. I'm sorry. And the bottom three photographs here, they deal with pictures that we took on June 25th that turned over to the prosecution a long time ago. The upper left-hand photo, the bottom photograph over here is one of their pictures. The jeans are jeans that a photograph taken of Goldman's jeans, I believe, at in Albany. But they went and took the same photograph, so their own photograph back. And then the next two pictures are the envelope and the piece of paper, which are their pictures. After that, Your Honor, are just their pictures. That's an imprint on the piece of paper, a close-up of that, and the imprint on the envelope, and a close-up of that. And then we also have, as I've shown Mr. Goldberg, these boards. We have larger blow-ups, but these pictures, this picture, this one, this picture is this one. will do a blow up on the Elmo of their own picture. And then for this other board, we have another larger version of this piece of paper and another blow up of their picture of the Elmo. So basically, you're dealing with their pictures. And
All right, we're in the
my alternative, I think we should be glad to do all this under any ruling or anything conceivable to me in terms of discovery issues. But if, and this is the order in which we planned it. If worst comes to worst, we'll just do their pictures on imprint evidence at Bundy. But I mean, I see no reason, given these photographs, and that they're their photographs, and they received, months ago, in March, they received these photographs of the imprints, the imprint evidence.
How about the notes with regards to those
They received those too.
in March? All right. Mr. Goldberg?
Oh, wait, well, I don't know. You should tell us what's that.
I'm not sure, Judge. I have all of that, what we turned over and what was not turned over, as do you. I'm not positive about whether notes about those pictures were turned over, but the pictures were.
All right, Mr. Goldberg?
Anything was done other than just take a picture.
Well, Your Honor, as to the first board, which we've already discussed briefly, Mr. Scheck's proffers to, by the way, may I have permission to stand here?
Oh, absolutely.
Mr. Scheck's proffer is not specific enough for me to be able to say whether or not we reject. Obviously, a very generic description may be appropriate. It may not get us into any areas where there are discovery violations, but I have a feeling he's probably intending on doing more than that. And it may be difficult for the court to rule on a question-by-question basis because the court hasn't had the opportunity to completely familiarize itself with this issue. As to the charts, we didn't discuss these because I didn't think we were going to get to them yet, but we had some objections to all the charts in terms of the word evidence. Because many of the things described, not so much on these charts, but some of the others, more particularly, such as with respect to Ron Goldman's genes, may or may not be evidence. I think it's going to be for the jury to decide. Because there are possible impressions on the genes, and we can't even be sure that they are impressions. In many other cases, the probative value of the evidence, if any, is concededly non-existent.
All right, well, Mr. Goldberg, let me ask you this,
But
though.
as to the discovery, I wanted to get into that too.
Yes.
All right. All counsel is talking about is when we have the photos. First of all, if you look at the close-up photo of the imprint on the envelope, that photo we received on the 3rd of this month. This, and what they are doing is they are linking this photo and also the close-up of it in with the rest of this entire board as to this imprint evidence. And we didn't receive any documentation as to the significance of an analysis and interpretation that Dr. Lee rendered. And he's a forensic scientist. He doesn't just look at photos and say, here's a photo. He gives an opinion, he undertakes an evaluation, and he expresses that as an expert to a jury. And that is
All
what
right,
he's
where in this pile of reports that you gave me is the report regarding this particular item?
Well, this particular item, the eyeglass envelope is probably going to be referred to in a number of different piles of documents because they refer to it more than once. But let me see if I can find the specific one, Your Honor.
Well, I
Or
mean,
one
did
of
you
the specific
did you or your law clerks prepare a chart as to each one of these issues and cross-reference it?
Well, the only thing that would be practical for us to do, Your Honor, we'll do as much as we possibly can at the court's direction. Would the court like us to take their charts and for the items of evidence on their charts, begin to cross-reference them?
I can,
Because we can do that. But there are many other items that Dr. Lee may be testifying to that are not on the charts.
Well, my question right now is, can you proceed with this one chart, marked 3 of 3, imprint evidence at Bundy, and the steps in forensic examination? Can you start with at least those 2 charts today?
imprint evidence abundant?
Yes.
No. Because this was one of the key ones that we, and the most important ones that we objected to. We did not find out in discovery that they were claiming there was an imprint on the eyeglass envelope until this month.
Well, I think that Dr. Lee's report indicates it, but more to the point, here's the notes that were turned over on March 24th, which describe these imprints found at Bundy by Dr. Lee. So it seems to me that what we're talking about on this source create are two pictures that they've had since March, notes concerning those pictures that they've had since March, with little diagrams of the pattern the court sees. Their own picture from June 13th, a picture of the jeans which they saw themselves and they've had in their possession for all this time. And when we took a picture of it, their people were taking a picture of it. And then it's their own, everything else is their own pictures here. And it seems to me that what Mr. Goldberg is saying is that they have an opportunity to have their own reconstruction experts, and they've had them, look at the same photographs, do close-up, look at the same imprint evidence, and draw their own conclusions. Basically, this is Dr. Lee's interpretation of scientific facts. They should have reported about it. All these raw materials and the notes have been all available.
Well, this is the point, Your Honor, just to drive it home. We had a witness by the name of William Bodziak testify on shoe prints. If the court recalls his testimony, he really didn't do anything except take all of the crime scene photographs that the defense had access to for months and months and put overlays on them, and then he generated a report regarding his findings. If I stood here and said, well, Judge, I don't need to give them the report from Bodziak as to his findings, because they have the same photographs for months. They have the crime scene.
All right, Mr. Goldberg, hold on. Mr. Scheck, the report that you've handed me, which appears to be dated 6/25/94, does not include any observations regarding prints on the envelope that I can see here.
It
Oh,
does.
no, I'm saying that deals with the parallel line imprints on the walkway at Bundy. That was what I was.
No, I'm asking about chart 3 of 3 here, imprints on the envelopes. I'm trying to get something in front of the jury right now is what I'm trying to do.
Well,
Would you help me? Would you tell me what report this is mentioned in?
these,
Yes.
well, it's mentioned certainly in his final report. And these are their pictures. I mean, I'm at a
No.
loss.
Answer my question. Which report mentions the imprints, the finding of imprints on these two items on your board 3 of 3? Just tell me which report.
That's in Dr. Lee's final report. And also.
Which is dated what day? I don't think I
July
have.
15th.
All right, I don't think I have a copy of that.
Oh.
Mr. Goldberg, did you provide me a copy of that?
No, I didn't. Oh, will I? Yes, I will.
All right. In Dr. Lee's notes, where are the observations regarding these?
In Dr. Lee's report of July 15th,
No, in his notes, not his report, his notes.
there's also observations of the imprint on the envelope on
Opening.
from the Albany inspection on February 17th to 19th. There is also reference to the March 4th, 1995 visit to the LABC crime lab, where we examined the envelope, pictures were taken, and Mr. Matheson was there. In fact, it's Mr. Bodziak, I believe, talks about the imprints on the envelopes in his own reports. They were standing there while we took these pictures and made these observations. That's why I'm having trouble with all this. I thought that,
All right, so what's Mr., all right, what is the date on Dr. Lee's final report?
The date on Dr. Lee's final report is
July 15th.
And when was that turned over?
July 17th. But the point is that the notes weren't turned over until the 8th of this month.
Do the notes include an opinion that these are imprints?
I believe that they do. And there may be a sketch, and I'd have to go through. I mean, the point is, Your Honor, this gets us right into the heart of the discovery dispute.
Well, here's the issue, though. Do you have the evidence in front of you, or are you aware of it? Answer is yes. It's the prosecution's evidence and the prosecution's agency that collected it. Are Dr. Lee's opinions that he is going to testify included in his report dated in mid-July that was given to the prosecution in mid-July? Apparently, the answer to that question is yes. That envelope and apparently that piece of paper, my recollection is that nobody bothered to pick it up. So it's off somewhere, who knows where. The issue is then what's fair at this point. If Dr. Lee's observations were and final report was made available to the prosecution in a timely manner, which it appears to be within days of the completion of the report, then I can't find a violation at this point. I'm not inclined to do that. Preliminarily, I'm going to say that the defense can use this board today with the jury. Let's proceed. Let's have the jury, please. Now, we're joined by all the members of our jury panel. Dr. Henry Lee is on the witness stand undergoing direct examination by Mr. Scheck. Mr. Scheck will continue for another half hour.
Thank you, Your Honor. Dr. Lee, did you have an opportunity to visit the Bundy scene on June 25th?
1994, yes.
And before you went there, were you able to look at some pictures that had been taken of the crime scene?
Yes, sir.
And what is the difference between a crime scene investigation and a crime scene inspection?
A crime scene investigation involves more library-type investigative procedure. Start from the beginning, step by step to the end. Usually involving an original scene or well-protected scene. A crime scene inspection usually for a limited purpose, for certain specific reason, usually not involve a lengthy process.
Were you able to do a crime scene investigation at Bundy?
No.
Why not?
I arrived Bundy scene at 6:40, June 25th, 1994. And my instruction is have to be complete before 7 o'clock, so you only have 20 minutes. In addition, that's not an original crime scene anymore. Already processed, evidence already picked up. So I only can do a limit inspection, which is limit among a specific purpose, not to do a complete reconstruction or a complete investigation.
Was one of your purposes in going to Bundy to look for imprint evidence?
Yes, sir.
Your Honor, I'd like to have it forward.
Thir- 1337.
Dr. Lee, could you describe for us, please, what an impression is and what an imprint is?
An impression is a three-dimensional representation. An object leave an indentation, have the width, length, and depth. For example, a footprint in snow, a tire track on the beach sand, or a soft soil surface. Another good example, a bullet fired through a gun. That length and groove left an impression on the spent bullet. Those called impression. Imprint is a two-dimensional representation. Only have the length and width, but no depth. For example, footprint left on a hard surface, such as walkway, hardwood floor, piece of paper. We don't have the depth, only have the length and width. A fingerprint left on a surface, a wood surface, that's another imprint. However, if a fingerprint left in a soft material, putty or fresh painted paint, now you have an indentation. A imprint not limited to shoes, foot, can be fingerprint, can be ear print, can be lip. Sometimes people have big nose, can have a nose print. So variety of imprint evidence which a criminals can find at the crime scene. We generally look at the width, length, and depth, determine that's an impression or an imprint.
Now, were you able, at your trip to Bundy on June 25th, to identify certain imprint evidence in the walkway?
Yes, sir.
And could you please come down and point out to the jury where those were? And as you do that, I'd like to mark two other boards, or mini boards, we'll call them, the photographs, and I'd like to make make them A and B.
All right.
Your Honor, may I step down?
Yes, you may. Mr. Scheck, which board do you have up there right now?
We have 1537 up there, and 13.
What is the title of the board and what number?
1337. It's entitled Imprint Evidence at Bundy. And
What number? One of three?
it's marked 1 of 3.
One of three.
And I'd like to mark as 1337A, a blown-up photograph of the photograph that is in the bottom right-hand corner of this exhibit. And I'd like to mark as 1337B, another blow-up of the middle photograph at the bottom of the board entitled Walkway 62594.
All right, Mr. Scheck, there are no victims' remains on this board, correct?
There are no.
All right, Mr. Bancroft, may I see this, please? All right, counsel, I thought we were going to do another one.
Now, Dr. Lee, could you please describe what it is you found on the walkway on June 25th?
On June 25th, 1994, I arrived at Bundy's. I found quite a few imprint evidence which consistent with footwear imprint. The majority have a specific pattern. Later was identified to be consistent with Bruno Magna type of shoewear. In addition to those shoewear evidence, I noticed a different design, a parallel line design type of pattern. Subsequently, I photographically documented those and with a scale to demonstrate existence of such imprint evidence.
Are the photographs of 1337A and 1337B blow-ups of the photographs that are on the board 1337?
Yes, sir.
Could you, I guess starting with 1337A, and then moving to B, and then moving to 1337A, identify this parallel line imprint pattern you've described, and indicate where it is on the board diagram and on the larger diagram. Photographs, I'm sorry.
In this small picture labeled Walkway, June 25th, 94, the center photograph of a lower set of a picture. This one consistent with a heel print, consistent with a subsequently aging Bozia identified that's a Bruno magnet. Adjacent to that, have a series of parallel lines of another imprint, have same type of appearance. This large photograph, which shows this parallel line design, this Bruno magnet, in addition have some wiggly line pattern. But this parallel line shows a series linear design. It's consistent with a imprint.
Dr. Lee, could you draw a circle around using a blue pen, the imprint, parallel line imprint that you're talking about? Now, moving to the photograph on the bottom right of the board and the larger blow-up 1337A, could you describe what's on those photographs and their relationship to the one you've just discussed?
This imprint was found in the middle row of number 10 tile on the walkway, start from the first staircase, recounting the number 10 tiles. Have consistent with that, again, parallel line design. And this one is more complete. Its pattern resembling to a shoe.
Could you, it's possible to identify here on 1337A the design that says a parallel line imprint pattern that resembles a shoe?
Yes.
Now, turning to the bottom left hand photograph here, what is this?
This is a photograph submitted to me by Attorney Shapiro. It's a photograph took by LAPD photographer. I did not receive a photo log. Tell me which picture from where.
Non-responsive.
Sustained. Next question.
All right. What is the significance? What did you receive a photo log?
No, I did not.
Were you able to tell which pictures were taken in which order?
I cannot make a such determination.
Are you able to place where this photograph comes from in terms of the tiles on the walkway?
Somewhere along that path.
Would it assist you if I put this picture on the Elmo in terms of being able to identify where the parallel line imprint is on this picture?
Well, it assumes facts, not an evidence.
Sustained. Raise the question.
Is there a parallel line imprint on the picture taken on June 13th by the Los Angeles Police Department that is consistent with the other parallel line imprints you found on June 25th?
Yes.
Mr. Harris? Yes. Oh, could we mark this print 1337C?
So, Mark. This is the lower left-hand photograph.
That's correct, Your Honor. Thank you. Now, Dr. Lee, I know that we worked a little bit with the point maker. Could you please direct Mr. Harris and show the jury?
This is only a small portion area.
Mr. Robertson? You direct.
Along this area. I'm not too good in drawing this. This consists of a series of linear formation. It's a very small portion of imprint evidence.
Could you put HLC in the upper left-hand corner and we'll print that out? Mr. Harris will do that, actually.
That's all right? Oh,
Yeah,
no.
that's good.
Okay. You do it again. That's not my emission. HCM.
Oh, you did say HL.
Did I say HLC? My apologies. Now, Dr. Lee, you mentioned before impressions. Are there techniques available for recognizing, preserving, and documenting shoe impressions in soil?
Yes.
Is the area depicted in the middle of this diagram that represents the closed-in area, you're familiar with that?
Yes.
Is the soil in that area the kind of surface where a forensic scientist could recognize, and if it were present, do something to preserve a shoe impression?
Yes.
What would one do?
Generally, we rely two techniques. One, photographic technique with a scale. Second, called casting. Generally, we rely on plaster of Paris, which the stuff we put on the wall. However, we use much better quality. Generally, we prefer the dental stone to make a cast. That's a method commonly used for preserve a three-dimensional impression evidence.
Now, are there techniques that you could have used on June 25th, 1994 to enhance the lines that you saw on the ground?
Yes,
What techniques are those?
we can use chemical technique or instrumental methods. A chemical technique more effective. We can use a tetramethylbenzidine spray or a autolytic spray, which will make a contrast react with the surface, especially contains blood or heme, and a reaction will shows up vividly in blue color.
Are those kinds of enhancement procedures potentially destructive of the imprints?
So it enhanced the imprint evidence.
But did you perform those on that day?
No, I did not.
And why not?
Our The order is very strict. I only can photograph, measure, and do simple tests. Cannot edit too many chemical or remove the whole workload.
Like to move now to a what would be called 1338.
Yeah, this is which number on the top right?
It's marked imprint evidence Bundy. Imprint evidence of Bundy 3 of 3.
3 of 3.
And then we're going to do sort of eventually. Now, Dr. Lee, what are the photographs on this particular board?
Or consists of 4 photographs, 4 pictures.
All right, hold on, Mr. Scheck. Are there any victims' remains on this matter?
No.
All right, Mr. Bancroft, may I see this, please? Thank you.
Consists of 4 pictures. The top 2 is original crime scene photograph provided to me by Attorney Shapiro. The lower 2 photographs is a close-up to demonstrate certain area on those material present at the scene, which namely on the left-hand side one is a piece of paper. We say irregular shape. Some blood-like stain was observed on it. On the right-hand side is an envelope, approximately 4 inch by 9 inch in size, with a number plate 104. That again have some blood-like material on the envelope. In a close inspection of this envelope and this piece of paper, I discovered their imprint-like pad exists on the paper. Those imprints have similar linear design, and those imprints made in blood. Some of the blood stain covers portion of the imprint, which indicative this imprint has to be placed on this envelope, this corner, before, prior to the blood applied to it.
Now, Dr. Lee, I'd like to show you how many more minutes? I'd like to mark what would be 1338A. And is this a, what do you recognize that to be?
This is an enlarged photo depict this piece of paper.
And 1338B, what is that?
This is a photograph shows a corner of this envelope.
I think Mr. Harris has them both upside down.
Yes.
In the interest of time, can I just display these quickly to the board? Now, Dr. Lee, are the parallel line imprint impressions that you have identified on the envelope and the piece of paper, could those have come from a Bruno Magli shoe?
Well, it's the imprint, it's not the impression.
My
That's a
apologies.
two-dimensional pattern. This two-dimensional pattern cannot B come from a golden magnet ship.
Could the imprint, my apologies, the imprint on the envelope, could that have come from Mr. Goldman's boot?
No,
How do you know that?
I studied the boot, did some measurement, and the saw pattern is completely different than this imprint.
Are the imprints that you found on the piece of paper and the envelope consistent with the parallel line imprints you found on the Bundy walkway on June 25th?
I only can give you a very limited conclusion with this regards to this issue. With the paper, I don't have physically the paper to study.
And why not?
This
Cause
paper,
for speculation.
Sustained.
Was this
Foundation.
paper ever collected by criminalists or police officers at the Los Angeles Police Department?
No personal knowledge. No.
Sustained. You can ask him if he ever personally observed that piece of evidence in the custody of the LAPD.
Did you ever personally observe that piece of paper in the custody of the Los Angeles Police Department?
no, I did not.
Is there a photograph that you have seen where this piece of paper is depicted?
Yes.
Your Honor, it's already in evidence. It's 10. Is this showing you that? And I believe this is cropped. So that
Which photograph are we talking
this is
about?
the photograph of Detective Furman pointing to the envelope with the piece of paper in it, but the body is cropped. This is Defense 1080. We've used this in Mr. Furman's office. Direct your attention to the screen. Do you see the piece of paper here?
Yes.
All right.
I can see in the middle of the photo, this pile, a piece of paper of similar shape. In this location near that corner. Also, I can see this envelope.
Is 1338A a blow-up of that piece of paper?
Yes.
Was this piece of paper with the parallel line imprint impression present, based on this photograph, at the Bundy crime scene on June 13th?
I did observe on this photograph, there are parallel lines exist in this location. Again, their blood stain on top of the parallel line make it difficult to see, but do exist. Subsequently, a close-up shows this clearly. They are parallel line in this area.
Dr. Lee, in your opinion, would this piece of paper be an important item to collect in doing processing this crime scene?
I wasn't at the crime scene, so I cannot make an assessment, but if my crime scene, I will collect it.
All right. Is a piece of paper such as this, besides the imprint impressions you're talking about, is it possible to examine both the front and the back of this paper for fingerprints?
Yes.
What about fingerprints in blood? Is that something in your experience that you can detect at a crime scene from a piece of paper such as this?
Yes.
How do you do that?
Because blood is red, it's visible. You have an imprint, a fingerprint, which commonly we can recognize. If a bloody fingerprint is not vivid enough, we can use an enhancement procedure those procedures been published, including my own paper, can enhance bloody fingerprint or footprint. Your Honor, I think that's the time.
All right, ladies and gentlemen, we're going to take our break for the afternoon. And Mr. Harris, can you take that down for me, please? All right, ladies and gentlemen, please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until 9 o'clock tomorrow morning. Dr. Lee, you may step down. You're ordered to return tomorrow morning, 9 o'clock. All right, let me see counsel at the sidebar with the court reporter, please. Mr. Goldberg, Mr. Shea.